Hi, my name is Audra Platt. I'm an estate planning attorney here at Pittman Law Office, and today I wanted to briefly talk about blended families. So, blended family, you come in with kids, he has kids, she has kids, you have different beneficiaries. Maybe this is your second or third marriage and you came in with assets and your spouse has assets, and you just want to make sure that when you pass away, your assets go to your beneficiaries. And maybe, perhaps, your spouse is okay with that. When y'all come into this marriage, you say, okay, I have my established assets, you have your established assets. When I pass away, you don't need my money, it's all going to go to my listed beneficiaries. Well, I caution you there, because under Florida law, your surviving spouse is protected. They have an elective share, which is a specific percentage and specific assets that they are allowed to receive, even if you had the agreement, verbal agreement, that you didn't need to give anything to your spouse. Even though that was your wishes and that was your intent when you passed away, they can sue to get a certain percentage. So be very careful. If you plan on getting married later in life and you have your established assets and you want to make sure that they go to your children or your beneficiaries, I would highly recommend looking into a prenuptial agreement, or if you're already married, then perhaps looking into a post-marital agreement. Because that is a way that you can ensure that when you pass away, your assets go to your intended beneficiaries. Because when you have a revocable trust or a last will and testament, and it says, hey, I'm disinheriting my spouse, they don't need my money, I want to give it all to my beneficiaries, they can still sue around that. So just because you have a trust or you have an estate plan set up, that does not trump your marriage. So marriage under the Florida Constitution and Florida statutes, that surviving spouse has rights, even if you have an established estate plan. So there are ways that you can get around the rights under the statutes and Constitution for that surviving spouse. Again, a prenuptial agreement or maybe a postnuptial agreement. And that is something that we can discuss in a consultation with you if you're interested. That's to ensure that you each keep your own assets the way that you want and they go to your intended beneficiaries. So getting married later in life can be complicated on the surface, but it can absolutely be even more complicated when you pass away. So those are things to consider before you get married. But if you have any questions, feel free to come to a free consultation or check out some more of our YouTube videos. Thank you.